in the Nursing Services Administration role.
Thank you, Mary. Elizabeth Woods.
Elizabeth Woods here. I was appointed by Governor Brown to the advanced practice role, and I chair the nursing practice committee.
Imelda Ceja-Buckowitz.
Morning, everyone. Imelda Ceja-Buckowitz, appointed by the governor as a public member. Welcome.
Thank you, Imelda. Susan Naranjo.
Public member appointed by Speaker Rendon.
Thank you, Susan. Jovita Dominguez.
Good morning. This is Jovita Dominguez. I was appointed by Governor Newsom in the education role.
Thank you, Jovita. And Patricia Nguyen.
Hi, I'm Tricia Nguyen. I was appointed by Governor Newsom as a public member. Welcome, everyone.
Thank you, Tricia. Our BRN Executive Officer, Loretta Melby.
Thank you, Board President Dolores Trujillo. This is Loretta Melby, or Lori. I'm the Board's Executive Officer. Thank you.
Thank you, Lori. And our BRN Board Counsel, Reja.
You'll get
Sorry.
it eventually. This is Reza, as you have. Good morning, everybody. I'm the BRN's legal counsel.
Thank you, Reja. We have established a quorum for today's meeting. BRN moderator, can we please open it up to public comment for items not on the agenda?
Instructions first, and then we can do that.
Definitely. Thank you.
Perfect. Good morning. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the board reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then move on to the next member of the public who has a comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. This is not a means to ask questions of the moderator or members of the board. Such inquiries submitted using this feature will not be answered. When asking a question, please make sure the question is directed at the host, me, in the drop-down. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when board members or senior staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will interject with a brief friendly reminder and mute your microphone. We will be open. Sorry, go ahead. Go ahead.
No. I was just going to read it. You read it. Thanks, Mark.
All right, I'm sorry. Public comment for items not on the agenda. We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, thank you. So at this time, a couple of things. We're going to reorder the agenda, and in place of 4.0 right now. We're going to take item 7. We have 2 guest speakers. We're going to take items 7.1 and 7.2. Elizabeth, would you like to introduce them?
Actually, Dolores, this is Loretta, and Lori, I can go ahead and introduce them.
That's
So
fine.
for 7.1, the Nurse Practitioner Advisory Committee updates, we have Samantha Gambles-Farr on our list. Board moderator, can you promote Samantha Gambles-Farr for her presentation?
She's been promoted.
Thank you so much. Also, Dr. Ray may be on the line as well. I'm looking to see if he's available, and he may be here for questions as well. I don't see him right off, but just keep that in the back of your mind.
So Lori, this is all part of the information only updates on the Nurse Practitioner Advisory Committee and the Nurse Midwifery Advisory Committee, is that correct?
Yes, so in previous board meetings, I, as the executive officer, is the one that has been giving the updates for the Npac and the Nmac committee on these agenda items. The request put forth by you, which was an amazing idea, was to have the chairs and or vice chairs of the committee to come forward and make the report out. And so Samantha is here. She is elevated, and she will present out the update to the Npac committee, and we'll be here to answer questions and interact with you guys. And I'm here for assistance if she needs it.
Thank you, Lori.
Morning, everyone. Good morning, Board President Trujillo and members of the BRN board. It's my absolute pleasure to be here to give you guys an update on the Nurse Practitioner Advisory Committee. Our last meeting was last week on Tuesday, on February the 8th, and we had a very full agenda items. The first thing that we discussed was implementation of our dates for the year of 2022. Those dates have been were established last year, but due to time constraints during our last meeting, we weren't able to put that action forward. However, our agenda item as it relates to the establishment of meeting dates for 2022 was set forth and were voted on, and they are in place. The second item on our agenda was to talk about the naming conventions for nurse practitioners. Specifically, we've been referring to Nurse Practitioner 103 and Nurse Practitioner 104. During that time, we opted to listen to members of the public and what their thoughts were on the matter as it relates to having specific names for those two different categories of nurse practitioners based upon what their practice would be. We got a lot of great input from members of the public and some members and a lot of members of our committee as it relates to that information. Some of the input was not to have any naming at all for nurse practitioners, just to remain nurse practitioners, and for that information to be delineated by the BRN, either through information posted on the website, and that there wouldn't be any additional name changes as it relates to 103 and 104. As a result of that discussion, there was a vote, there was a motion and a vote to only put a special name on Nurse Practitioners 104 as independent nurse practitioners. There was a vote by committee members and that action passed. So our recommendation coming to the board will be that nurse practitioners functioning under standardized procedures and nurse practitioners, what we've been referring to as NPs 103, will remain just as that. They will not have to put any additional information as they on their signature line. However, nurse practitioners 104 will have the delineation of independent nurse practitioners. Our next agenda item was related to us providing recommendations or guidance under subsection 2837.102 Subdivision A of AB 890. We are still working through this process. I'm sorry, can you hear me?
Yeah, I can. I just had a couple of questions around the first issue that you raised.
Yes, please.
Okay. The 104, they would be called a independent nurse practitioner. This is what would appear on their licensing, and they would need to also use that in their recordings, in their notes, in whenever they sign their names. Is that what you're suggesting?
Correct. That was the opinion of the final vote of the committee after a lot of discussion as to whether there needed to be any change at all, or whether it would just be delineated on for insurance purposes and for the public to actually look on the BRN website to find different, to essentially figure out which type of nurse practitioner they were. They did, there were a lot of members of the public felt that there wasn't any need for any additional, as we call it, alphabet soup behind nurse practitioners' names, as you know, there was a lot of concern that that would just promote more confusion. And so the committee felt that the final vote felt like it would just need to be for 104 MPs. So they would be the only ones that would be required to put in signature line as a part of their signature that they are independent nurse practitioners. Understanding that, you know, there's still requirements under AB 890 that state that those 104 MPs or independent MPs would have to notify their patients that they are not a physician or a surgeon, and that they would have to give them the option of seeing a medical provider, a physician or a surgeon. So those stipulations are already in place, but as far as making sure that the public knew that they were seeing an independent nurse practitioner.
And what this would be reflected in their licensing also?
Yes. So, and that is stuff, and that is information that we're working with EO Melby, and of course, the board will have final input on that. But the thought is that that information will be posted as part, when you do a license lookup, it would say what type of nurse practitioner license that they had.
Thank you, Samantha.
Thank you. Any other questions? I'm sorry. This is my first time, so admittingly, I should have paused to give opportunity for questions. Are there any other questions as it relates to the naming conventions for nurse practitioners? EO Melby, do you have any input on that? I see you raised yourself.
Yeah, no, that's great. Thank you. You did an amazing job, Samantha. I really appreciate you taking the time out of your day. You got coverage for your patients for this brief time right here, and gave a great report. This is an agenda item 7.3, and we will discuss that and get board vote on it at that point. So if there is additional questions, I will be available for that to kind of share with you guys what Samantha shared as well. And then 7.4 is also reference back to what occurred in the Npac committee earlier, where we talked about fees, and we'll give an update at that point. So do you have any further updates for Npac committee? Any additional information you'd like to share with our board, or any questions to our board, Samantha?
So we did have a discussion about guidance as it relates to disciplinary action that we have been discussing. Of course, understanding that there are time restraints as it relates to nurse practitioners when they are involved in disciplinary actions. And so the committee is trying to discuss and figure out what would be appropriate for us to be involved with in order to, and even if there's any need for us to be involved at all, or whether we would simply give input as it relates to disciplinary regulatory language that's being developed currently. The committee has stated that they would like to be involved in that process, and that at this time, that may be the only involvement versus additional involvement as some of the committee members have felt like there may be special circumstances or special disciplinary actions that the committee would like to be involved in. Of course, that would have to be something that we will have to continue to further discuss, because we want to make sure that any of our nurse practitioner colleagues that are in disciplinary action have due and swift processing time. And so that is something that we've also been discussing. Unfortunately, we did not have an opportunity to discuss fee analysis as it relates to Section 2837-104, subsection B2. We have not had any opportunity to even discuss or have any information brought to us as it relates to that subsection. And so we're waiting for that. And then as part of our meeting, we did have an update on OPES and the progress that they have made and what the actions will be moving forward. We've had some discussion about that in the past, but that is truly the first time that we had a lot of information given to us as it relates to what has been done, what will happen moving forward, and what the deadlines are and what they are hoping their deadlines will be as it relates to giving us information as far as what OPS will be suggesting as it relates to whether there will be any supplemental testing required for nurse practitioners in the state of California. Other than that, our committee remains very cohesive in their goal of working together to make sure that we are protecting the public, working within goal of AB 890 and its regulatory language, and truly working in the spirit of the bill to ensure that Californians have increased access to healthcare and that in protection of the public. So with that in mind, myself or Dr. Edward Ray, our vice chair, may be coming before you to give these presentations moving forward. And we really appreciate the opportunity to answer any questions directly. And this was an excellent idea. So we thank you. I send thanks on behalf of the committee. And at this time, I guess if there's any additional questions related to anything else that I've said.
I'd like to thank you and the committee very much, Samantha. This is long overdue and a lot of work. And I'm so glad that you have been selected to take on this role to get this in order, because it's a very difficult task. Thank you.
Yes, thank you. And thank you to all the other members of the board and President Trujillo. Thank you, Ego Melby. Thank you.
If you want to, we will, because this is informational only, we'll go out to public comment right now. And if you want to be present for that and listen, you can. If not, you can go ahead and exit, and I'll be providing an update to the Npac committee via email about the outcomes of today's meeting.
Okay, I will stick around to hear public comment, of course. Thank you.
Sounds great. Thank you.
Thank you.
So Betty, because there is no vote and this is informational only, you can take it to public comment.
Okay, let's go to public comment, please.
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Dr. Stephanie Dittmer would like to make a comment. 1 second, please. Go ahead, Dr. Dittmer.
Board of Registered Nursing, and thank you, Samantha, for your report on the Npac meeting from last week. As a physician here practicing in the state of California for over 10 years, I would like to make sure that when we move towards investigating what the proper naming should be of physicians and nurse practitioners and other clinicians in the future, that we really take into account what the spirit of the law was. And the specialized verbiage of the AB 890 was actually suggested and promulgated as part of the original intent to make sure that people understood what the difference was. Using the word independent or independence at this point in time is inconsistent with that spirit, and I think we should make sure that we use the language that was initially suggested. Thank you so much.
Thank you. Sergio would like to make a comment. 1 second, please. Sergio, I've sent you an unmute. Sergio, I'll come back to you. Katrina Reyes would like to make a comment. 1 second, please. Go ahead, Katrina. Oh, are you there? Oh, I lost Katrina. She lost her microphone. Okay, let me go back to Sergio. Sorry. Sergio, are you able to unmute your phone? All right, I will move to Ryan Spencer. Go ahead, Ryan.
BGYNs. Just like to align our comments with the previous speaker to voice our preference for the use of the term specialize and not the term independent for the reasons that she stated. Thank you.
Thank you, Ryan. Go ahead, Katrina. Katrina, go ahead.
Can you hear me now?
Yes, we can. Thank you.
Oh, perfect. Hi, good morning. Katrina Reyes with the California Academy of Family Physicians. Also like to align my comments with the previous commenters in that AB 890 provides a naming convention for these new NPs in Spanish, which is made clear in the statute, and it's enfermera especializada, which in English that most closely translates to specialized nurse practitioner. So providing another title might be confusing, and we want to make sure that we are making it clear to patients the kind of practitioner that they're seeing. Thank you very much.
Thank you, Katrina. Don Shanks would like to make a comment. 1 second, please. Sorry, Don Shinsky.
On behalf of the California Society of Dermatology and Dermatologic Surgery, we just want to concur with our physician colleagues. The statute seems pretty clear on this, and for the sake of simplicity and consistency, I think the Spanish naming convention is the most suitable. Thank you.
Thank you. Dr. Cynthia Jovano would like to make a comment. 1 second, please. Go ahead, Dr. Jovano.
Hi, thank you for taking my call, and thank you for the presentation in regards to the discussion on the Npac committee. I do just want to address the finalization of the 104 NP signature, which is again still redundant. And if anybody here understands billing and insurance, me as a billable entity, it is already required by large private insurances to indicate to our patients when they sign up to see us that we are nurse practitioners. And this is just a duplication of our identifying our roles within the healthcare arena. And so putting even on our signature line an independent practitioner, we're still independent when we are billing. And currently under law via CMS, whether we're a 103 or a 104 or with a standardized procedure, we can bill independently. And this is already transparent to our patients when they come see us. So I just want to highlight this, that this is duplication of efforts. Thank you.
Thank you, Dr. Yovanel. Marco Lizarraga would like to make a comment. 1 second, please. Go ahead, sir.
Okay, gonna start over again. I had already started.
Yes, go ahead. You're fine.
Okay, my name is Marco Lizarraga, and I'm calling in on behalf of La Cooperativa Campesina de California and a couple of my members, which are Produce and the Center for Employment and Training. And of course, we serve farm workers throughout the state of California. We ask that our suggestions are incorporated into the regulations. None of our suggestions for the regulations have been included. Currently, you're placing all burden on patients that are Spanish speakers and many times have minimal education. And I know that firsthand. A Spanish speaker will likely not know what letters next to a name mean. When patients come in through the door of a small, medium medical practice, they should be informed in writing that they are not seeing a doctor and that they have a right to see a doctor. And I'm telling you, this is a firsthand experience that I've had in Imperial Valley, my parents and I. The regulations that you have released do not protect low-income patients that are in rural parts in California. Patients should know what services nurse practitioners can provide and what procedures they are not authorized to do. This information should also be provided in writing. For name conventions, thus, we request that the English convention for both 103 and 104 nurse practitioners be specialized nurse practitioner. ABA 90 requires the Spanish notification of specialized nurse. La Cooperativa Campesina has been servicing patients for over 40 years. Many times, regulations are passed without thinking of those communities that are most vulnerable because of their income status and because of their immigrant status. Thank you.
Thank you, sir. Sergio would like to make a comment. 1 second, please. Go ahead, Sergio. Sergio, I muted you. You're going to have to unmute yourself again.
Is that good now?
There you go, sir. Thank
Okay,
you.
I'm so sorry we couldn't. Okay, anyway, my name is Sergio and I'm calling on behalf of La Casa del Diabético and Unión de Guatemaltecos Inmigrantes. And truly we are, calling and asking that our suggestions to be incorporated and to be part of the regulations. We believe that truly none of the suggestions that we have made in the past have been included and incorporated. And this is so critical, because most of our patients are Spanish speakers and the burden is put on them. So some of them don't have a lot of education. I mean, their level of education is minimum, and a Spanish speaker will likely not know what letters mean to a name. So when patients come in through the door of small or medium medical practice, they should be informed in writing that they're not seeing a doctor, that they are seeing someone else, right? I think this is critical and this is important. So we are asking you that in these areas where low-income patients live, rural parts in California, that can be protected. And by including all of these regulations, I think it will be very important. So thank you for your time.
Thank you, sir. Alejandro Solis would like to make a comment. 1 second, please. Go ahead, sir.
Can you hear me?
Yes, sir. Good morning.
Good morning. My name is Alejandro Solis. I am calling in on behalf of Los Amigos de la Comunidad Imperial Valley. We ask that our suggestions are incorporated in regulations. None of our suggestions for the regulations have been included. I have commented at past NPAC hearings and none of our recommendations have been considered. Currently, you are placing all the burden on patients that are Spanish speakers and many times have minimal education. A Spanish speaker will likely not know what letters next to a name mean. When patients come in through the door of a small or medium medical practice, they should be informed in writing that they are not seeing a doctor and that they have a right to see a doctor. The regulations that you have released do not protect low-income patients that are in rural parts in California. Patients should know what services nurse practitioners can provide and what procedures they are not authorized to do. This information should also be provided in writing. For name conventions, thus, we request that the English convention for both 103 and 104 nurse practitioners be specialized nurse practitioner. AB 890 requires a Spanish notification of specialized nurse. Stricter disclosure requirements should be placed on nurse practitioners because they receive less training and education than a doctor. Thank you for allowing me to give comments.
Thank you, sir. Committee Chair Woods, there are no other public requests for comments. Would you like me to close this window?
Yes, thank you, Mark.
Choose to, we can move on to agenda item 7.2 and get the update from the Nmac committee, or you can open it back up to any potential discussions or questions that the board may have for Samantha prior to her exit.
Excuse me. I have some issues and comments to make about the whole thing. And while I certainly do appreciate that our Spanish-speaking patients may not understand the role of a nurse practitioner, what they do, what they can't do, I think many of our patients don't understand the role of a nurse practitioner and what we can do and not do. And I say that with 43 years of experience as a nurse practitioner. And at first, back 43 years ago, people would ask about nurse practitioners and what they did. Now, I've seen thousands of patients. Nobody really asks. And I introduce myself as a nurse practitioner. There's not many questions around what I do, what I don't do. Whether people understand what I do and what I don't do is a whole different story because it's not brought up. And I think adding another initial or name after nurse practitioner is more confusing than anything else. I think that nurse practitioners will be differentiated according to whether they're using protocols or not. Most patients don't know about protocols. So I'm just concerned about adding so much information that it confuses patients more than anything else. And I think the people who are not independent nurse practitioners are mostly functioning just as well as the independent nurse practitioner. So this is my personal take on it with many years experience as a nurse practitioner. So I'll just put that out there and see if anybody else has any comments or issues around it. Thank you.
Thank you, Betty. Did we want to move on to agenda item 7.2, or did you have further questions? Just so that everybody does understand on the call that after we get the updates from the Nurse Midwife Advisory Committee, that agenda item 7.3 is specific to this discussion, that we can continue to have this conversation and kind of go back and forth and open this back up for further kind of communications around this when we get to 7.3.
Yes, why don't we move on?
Okay, thank you, Betty. Do you want to go to 7.2? And Samantha, you can exit now and go take care of your patients. Have a great day, and thank you for coming forward and helping us with this.
Thank you, Chairperson.
Okay, let's go on to 7.2, the Nurse Midwifery Advisory Committee. Informational only, and the updates on that.
Thank you, Betty. And this will go the same as it went with the update coming from the chair for the Nurse Practitioner Advisory Committee. So this is the Nurse Midwifery Advisory Committee, and Mary Kay Phillips is the chair of that one. And she has been elevated to panelist, and she will provide the update, and I will stay here for assistance if needed.
And can everyone hear me? My name is Mary Kay Phillips. Yes?
Yes, we can hear you, Mary Kay.
Thank you. I am the chair of the Nurse Midwife Advisory Committee, Nmac, and we held our quarterly meeting on February 8th to share what was covered at that meeting, primarily that may be of interest to you. First off, we had a pretty detailed discussion about access to the California Department of Public Health's screening information systems. This would be CalGen as well as prenatal screening. Currently and for quite some time, midwives as well as other nurse practitioners they must have a delegator, a physician delegator, in order to access those portal systems. This has caused a lot of complaint recently and a lot of questions. But fortunately, Lori Melby shared with us at that meeting that CDPH is going through some technology upgrades, and by May, we are hoping that the CalGen prenatal screening portal and the SIS system information system will have a new access system that they call Ideal, and that should ease access and no longer create this barrier where the nurse practitioners and the midwives, and I believe PAs as well, have to have a delegator assigned in order to access their systems. So a detailed discussion and fortunately a positive response with some hope for change by May. Do you have any comments, Lori?
Sorry, it took me a second to unmute. So what Mary Kay is talking about is currently the Medical Board of California uses an electronic system called Ideal that allows for CDPH to verify current licensure. And based on that licensure, they are able to view results or order specific tests. When this was implemented a few years back, it was prior to the implementation of AB 890 and prior to the implementation of SB 1237. They hadn't even been introduced into the bill process for it to become law. And at that point, we didn't have, as the BRN, did not have any independent practitioners. So the board did not take place, did not work within that system. Since the passing of SB 1237 and AB 890, we now have independent practitioners who need to have access to CDPH to utilize these systems. Since July of 2021, I've been in close contact with them, working on getting this process rolled out. It will continue to use IDEAL that was developed through the Med Board to validate and verify licensure. So it will have that branding on it, but it will go through CDPH. Our nurse practitioners, our nurse midwives will have the ability to place orders. And all other licensed RNs will have the ability to go in and view results once they register through that system and get validated through CDPH. And yes, Mary Kay is accurate with a planned implementation per CDPH, because this is not owned by BRN, it's not owned through DCA. This is through an outside state agency, and CDPH expects to go live in May.
This is great. This is another way that nurses can do what nurses do and make it easier for them to take care of patients. Thank you.
Yes, thank you. Are there any other questions from the board regarding this issue?
Mary Fagan, I have a question. Was there discussion about naming conventions for nurse midwives in the same vein that there was for nurse practitioners?
Not at this meeting, no. And in general, no. I think it's different for nurse midwives because we are titled certified nurse midwives and have been. I don't think that it's generated quite the confusion. There may be a confusion sometimes with the general public about what midwives can do versus obstetricians. But there has not been a conversation about naming or changing titles or letters or no, at least with our committee, no.
This is Reza.
Thank you, Reza. I was going to jump in, but I'll let you jump in, Reza. Thank you.
I was just going to add one of the key differences in my mind is that for the nurse practitioners, in order to be a 103 or a 104, as we're calling them now, nurse practitioner, you have to meet certain requirements and show to the board that you've completed certain number of hours, etc. On the nurse midwives side, SB 1237 didn't really impose anything like that. It just states that the certificate to practice nurse midwifery authorizes the holder to, and it explains the expanded scope that is allowed under that bill. So a little bit less of a need for kind of a differentiation in naming, to the extent that there's any need for differentiation at all on either side.
Thank you for that.
Any other questions? And I'll move on to the next item that we discussed. No. So the committee reviewed FAQs. So just a little bit of a background. In our original, and Lori probably shared this with you previously, but Nmac had decided, because of the nature that SB 1237, the verbiage that was used in SB 1237, that we did not require or need to create regulations, that the bill spoke clearly and regulations, and it was written with that intention if you speak to some of the authors. So limited need or no need for regulations, and Nmac agreed with that, and that was decided at, if not our first, our second meeting. But we did agree that FAQs were probably indicated, and so the committee has broken down the bill into sections, and each individual has worked on creating FAQs that can be posted on our website and should be easily accessible and hopefully answer those frequently asked questions for the general public, for midwives in practice, for employers of midwives, for hospital systems that have questions maybe about privileging, etc. So at this meeting, we reviewed some of those FAQs as they've been presented. We've got feedback from Reza. The process is still ongoing, but we did agree that we could start posting them on the BRN website. We still need maybe an introductory generalized paragraph, and we still, they're not perfect. So it is a work in process, but we feel like there is urgency to get this information posted on the BRN website, because there are a lot of questions in the community, and there's a general feeling that our law has been in place for over a year, and yet a lot of things haven't changed in practice because people are uninformed and they don't have a good source to go to for confirmation of just exactly what the new law states. Any questions or comments? Reza, did you want to jump in there?
No, I didn't really have anything to add unless there's anything specific you want me to add. One of the things for the board's information, that I was reviewing the FAQs for from a legal perspective was just to ensure that the FAQs kind of remained within the scope of what we can address via an FAQ and didn't kind of creep into so-called underground regulation territory. So yeah, I appreciate the hard work that went into drafting those, and that was kind of my main focus in looking over those.
So it was agreed by the committee that we could post what we have with the approval of the BRN and with the legal review, knowing that we may readdress them, add, and continue to let it be a work in progress. Certainly as questions come in, maybe we would know that a particular FAQ needs more clarity or even the creation of a new FAQ related to questions. So that's in the works right now. Any questions from the board regarding that issue? No? We also discussed the fact, along with these FAQs, that we clean up the BRN website regarding all things related to midwifery. There's general concern that we have a lot of very old information, a lot of links that are simply not consistent with the new regulation. It's very confusing to anyone going to the BRN website for confirmation regarding, the most current updates in legislation. Some of these links are 10, 12 years old, if not 20, some of them. And so it was decided by Nmac that we just needed to dive in and clean this up. We agreed to create a subcommittee of 2 members that would kind of take this on, really just addressing one link at a time that has any reference to midwifery, and making sure that whatever the subject of that link is, that it is current, that it is not sharing wrong information. And as those 2 members identify or not rewrite necessarily, but address it, strike, underline, we'll resubmit those to the BRN for agreement or correction. And maybe some things just need to go away completely. But the website needs to be cleaned up, and we just weren't sure where else this was going to take place. So Nmac's going to take it on. Any questions?
Mary Kay, just a quick update. That was an original project that was going to be started by the APRN committee. However, with the statutory requirement to have an Nmac and an Npac, the sections of the website that are specific to those professions went to those committees, and APRN will continue to work on CSS and CRNA updates. And we are additionally moving to make a separate web page within our website that will just be nurse midwifery related, very similar to the process that we're doing with nurse practitioners. Right now, we have a nurse practitioner page that is specific to the implementation of AB 890, and we'll be growing that one as well. That'll be specific to nurse practitioners, so they can kind of look in a kind of a one-stop shop versus having to go through multiple layers to find additional information. For history, for those new board members, there was a process that was used in the past where they would do kind of board statements, and they would create a PDF that did not have linkable items, that did not have updatable items, and that would be published to our website. We are in the process updating the website, removing those, and we will begin working very closely with the Npac and Nmac to really kind of pull any of those PDFs off of our website, because we cannot easily update them. And the intention will be to move forward is to link those to direct source information. That way, if a statute is updated, it will immediately go back to that statute, and there will not be a form that needs to be updated. We want our website to be very, very clear, easily to manage, and current. And that is going to be quite the undertaking. And thank you very much, Mary Kay, and your advisory committee for helping us with that. That's a huge undertaking that's been needed for a while.
Thank you. And lastly, and we didn't have a great deal of time to work on it, but we have decided that Nmac needs a mission statement as well as goals, primarily to keep us focused and in line with the public interest regarding SB 1237 and quality access for the general public, as well as midwives in the community and their employers, so that we primarily, and you'll have to understand that I'm a retired military officer, and so I find it hard to run a committee that we don't have like a mission and goals. So we're working on that, and each member is working on it outside individually, and hopefully we can come together again and maybe by the May meeting have goals and a mission statement available, posted on the midwifery page.
Thank you, Mary, and your committee for taking on this amount of work. Again, a lot of it's long overdue.
You're welcome.
The work that you have been putting into it.
Thank you. And that's it. Any questions?
Since this is informational only, we don't need a board vote. Betty, you can take that out to public comment.
Yes, Mark, could we go to public comment, please?
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board Member Woods, Committee Chair Woods. There are no public requests for comment. Would you like me to close this window?
Yes, please. Thank you, Mayor. Okay, Lori, do you want us to continue with the Nursing Practice Committee, or do we want to go back to the beginning of the meeting?
We will. Thank you, Betty, for asking. We'll go ahead and go back and start the original agenda items, and then we'll come back to practice committee. So we'll open it back up to Dolores. So if you can back the slides up, board moderator, that'd be great. Thank you.
Okay, moving on to item 4.0, review and vote on whether to approve previous meeting minutes. These are for November 17th through 18th, 2021, November 30th, 2021, and January 13th, 2022. Do we have any questions from the board on these minutes?
This is Imelda Ceja Butkowitz. I move to approve the minutes for November 17th through the 18th, November 30th, and January 13, 2022.
I will second your motion, Imelda. Thank you.
This is Tricia. I have a quick comment.
Sure.
Although I was at the January 13th meeting, I was not at the November meetings. Yes. I will give a courtesy vote in favor, but I just wanted to make that on the record. Thank you.
Thank you, Tricia. Okay, let's open it up for public comment, please.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Amy Thatch would like to make a comment. 1 second, please. Go ahead, Amy.
Not sure if this is the right time. Sorry, I just joined into the meeting. My comment didn't necessarily have to do with the current topic that's being discussed. I'm sorry, I'm learning the procedure. So if you could just delete this, that'd be great. Sorry about that.
Thank you. No problem. Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, please. Thank you. All right, we'll take it to a vote. Dolores Trujillo votes yes. Vice President Mary Fagan.
Although I wasn't present for the November 17th, 18th meeting.
Okay.
I think my vote still counts.
But you've read the minutes?
Yes.
Okay, great. Elizabeth Woods?
Woods, yes.
Imelda Ceja Butkowitz?
Yes.
Susan Naranjo?
Susan, yes.
Jovita Dominguez?
Yes.
And Tricia? When? Yeah, okay, thank you. Okay, moving on to the next agenda item. Just as informational only, we are planning to break for lunch at 12 p.m. to 1 p.m. So item 5.0, discussion and possible action regarding declaratory decision with precedential effect on the question presented by Atkinson, Andelson, Loya, Rude, and Romo. Does a registered nurse commit misconduct subject to disciplinary action when the nurse administers medicinal cannabis to a qualified patient student on a school campus pursuant to a physician's care plan? I believe this is you, Reza, that's going to speak on this. Okay, thank you.
I'll introduce this. For your information, we have the attorney that submitted the request for declaratory decision, Michael Davis, in our list of attendees. So if you have any questions that you'd like to direct to Mr. Davis, we can have him promoted to panelist. This item, most of you may recall, Tricia, you're, I think, new since this originally came up, but excuse me, most of you will recall we've talked about this once or twice before at previous board meetings. This was a request submitted by the law firm that's identified in the agenda item. And it's a request for a declaratory decision. And I think I kind of talked through about what that is in general terms, but just I'll briefly rehash that. So a declaratory decision, it's actually defined in regulation. It's a written opinion containing a statement of undisputed fact and a determination of issues relating to the application of a state agency, rule, regulation, order, statute, or administrative decision as it applies to a situation in which the agency has primary jurisdiction. So in other words, it's a way for an agency to provide guidance regarding the application of the agency's statutes and regulations to a specific question that's presented. Typically, the general kind of circumstance where a declaratory decision is issued is where there's a question out there, and before a violation actually takes place and we're considering disciplinary action for the violation, a declaratory decision typically takes place before there is such a violation in order to provide guidance on what our interpretation of our laws are, so that the public and interested parties can understand our interpretation and avoid such a violation in the first place. So the request from Mr. Davis, their law firm represents, I think, a number of public schools or maybe public school districts, I'm not sure which, but they have been dealing with this question of whether school nurses can assist with the administration of medicinal cannabis to patients, typically for things like severe epilepsy or other conditions for which cannabis seems to be a pretty effective treatment. So that was the request. The piece about it being a precedential decision is that if whatever you decide on this question will be binding on the general public and not just Mr. Davis's clients who've brought this request forward. The procedure for issuing a declaratory decision is also prescribed in regulation. In order to do a declaratory decision and not, we've talked before about underground regulations. Those are typically rules of general application that the board puts out there and tries to enforce that don't go through the board's mandatory rulemaking process. As you know, that rulemaking process to establish regulations is also prescribed in statute and goes through the Office of Administrative Law and is a pretty lengthy process. In order for a declaratory decision to not kind of cross the threshold and be an underground regulation, there are specific procedures and there are limits to what can be adjudicated as a declaratory decision as opposed to the board establishing a regulation instead. So one of the key parts of this declaratory decision process was that we had to issue notice of the proceeding that it was taking place to any potentially interested parties. And so we were given by Mr. Davis's firm a list of potentially interested parties, which that document is in the meeting materials. So hopefully you've all seen that, and you've seen it before as part of prior meeting materials as well. But those interested parties included, just for example, school, I don't have the titles off the top of my head, so forgive me, but the association that represents school districts, school nurses, the California Nurses Association, the Department of Cannabis Control, the Office of the Attorney General, and the list goes on. In addition, in the interest of transparency and getting the word out to any potentially interested parties, we sent a notice to basically everyone on the BRN's email list, which includes our licensees, as well as anyone else that has signed up to receive the BRN's emails. So quite a few people received notice of this proceeding. Once we issued that notice, we were required to wait 45 days for members of the public to submit public comment. And we did receive some public comments. Those are also in the meeting materials. And all that has now happened. And the purpose of this agenda item, now that we've received public comment, we've talked about it before, it's now back on the agenda for you to discuss it with the benefit of having reviewed the public comments and considered the question and make a determination of how you think this question ought to be answered based on the BRN's Practice Act and regulations. So again, we're not creating a new rule here per se. We are applying the board's existing laws and regulations to the question presented. So I assume this will kind of be evaluated within the parameters of the BRN's existing scope of practice, statute, and the rest of our laws and regulations. So I guess I'll stop there. If there's any questions or anything else that you'd like me to address or cover, please let me know. Otherwise, I can turn it over to you. And as I said, if you want, we can allow Mr. Davis, Mike Davis, to be a panelist. If you have any questions you want to specifically direct to him. And then, of course, we'll hear from the public and go from there.
Thank you, Reza. Are there any questions from the board or statements?
Sorry to interrupt. One other thing, this is just a tangent. When the notice went out to the public that this declaratory decision proceeding was taking place, there were some who were a little bit confused about what was going on and whether they specifically were being considered for discipline or being accused of doing something that they never had any, experience with or practice or any involvement with in their practice. So just wanted to take a moment and apologize publicly to the extent there was any confusion. Again, this went out to nearly probably 500,000 people, given that it was issued to all our licensees. So a very small proportion of people, I think, were a little confused or concerned. But again, wanted to acknowledge that and apologize to the extent there was any confusion. The notice, just for your information, that was issued, the form of that notice is essentially prescribed in regulation, and we followed what was prescribed in regulation as closely as possible. There's a sample draft notice in the regs, so it wasn't, it wasn't our own drafting there. That was the only other thing I wanted to mention. Thank you.
Thanks, Reza. Right. Any questions or comments from the board?
We're going to be taking a vote on this. Is that my understanding?
That's my understanding.
So I say.
Betty, can you speak into your microphone a little more?
Closer to me.
Thanks.
Is that better?
Yeah.
All right. Can we say a registered nurse does not commit misconduct subject to disciplinary action when the nurse administers medical cannabis to a qualified patient student on a school campus pursuant to a physician care plan, government code, blah, blah, blah?
Yes, that is, you can make that motion.
Make that motion.
Essentially, that the answer to the question is no. That type of action by a RN, by a licensee, is not misconduct.
And that would be a presidential decision? Correct.
That's
Correct me
right.
if I'm wrong, was it? Okay.
Presidential decision. So going forward, just so you're clear on the process, we'll talk about it here. We'll give a chance for the public to make any comments that they'd like, and ultimately you will vote on whatever motion is made. And if that's the motion you'd like to make, Betty, that's certainly a viable motion. And after the conclusion of the meeting, a decision will be drafted and circulated to the board members, and you'll, of course, respond directly to me so that there's no communications outside of a board meeting amongst yourselves in violation of the Open Meetings Act. And once a decision is finalized that you all are happy with, that will be made public. And there are some rules about the publication of precedential declaratory decisions, which we will follow. And then it will be a binding decision. So in the future, if, just to give you an understanding of how this would apply, if a RN were to administer medicinal cannabis to a qualified patient student on a school campus, and for whatever reason the board brought disciplinary action against them, this decision would serve as precedent to establish that no, that's not misconduct subject to discipline. So going forward after the meeting, that's kind of how this plays out.
Well, I'm just thinking a little bit more about this pursuant to a physician care plan. I think we should have a physician, nurse practitioner, or PA. Why they're calling it care plan? It's really an order, per se. But there are nurse practitioners and PAs that work in school that order medication.
A couple things. Oh, sorry. I'll let you finish, Betty. The first thing is the term care plan. Mr. Davis may be in a bit better position to kind of speak on that than I am. But there's the physician's care plan. In addition, there is, I believe, what's called an individualized education plan, IEP. I could be a little off on that term, but that's a plan that's kind of put together amongst school administrators and the students' parents and those involved to kind of spell out additional parameters about, in this case, the administration of the cannabis or whatever the issue may be. As for physicians versus NPs versus PAs, I think we're talking here about physicians specifically because again, Mike Davis, better position to talk about this than me, but the Compassionate Use Act, which initially authorized and brought medical cannabis to California, specifically authorizes physicians to make recommendations for medicinal cannabis. It doesn't really address the authority of other healthcare providers like PAs and NPs to do that. We know that NPs have authority to order certain medications. But when it comes to cannabis, that's kind of regulated under a separate set of laws, the Compassionate Use Act, and that's where it's a little more limited to physicians. So that's why the question is really only focusing on the physician's care plan. We're not really getting into or answering the question of, do NPs have authority under the Compassionate Use Act, and what's going to happen under AB 890 and all that. It's a pretty limited scope of the question, and that's what we're answering.
Betty, do you want to clarify what you are stating with regard to care plan versus order? I think what you're getting at is it should be an order or under a nurse, under a doctor's order rather than care plan.
An order for
Yeah.
medication. We don't usually say a care
Care plan, yeah.
No, there are these other care plans within the educational system, so maybe that's why that language was used, but to me, it's not clarified.
Fair enough, yeah.
It's not.
And Reza, you're right, it is an IEP. And it's a plan of care. I mean, anybody can basically, I think this is what Betty's getting at, anybody can write a plan of care, but
Write an order.
an order is a little different. It's what the nurse follows, a doctor's order. Just because it's on a care plan, unless that order is in place, the nurse might be. Go ahead.
I don't know that this is necessarily going to answer, whether the term care plan is the best term or something else, but I know that in the history of, the Compassionate Use Act and medicinal cannabis and all that, this goes back, I think now, many years. I don't know how long ago that Compassionate Use Act was passed here, but I know that at that time there was some questions and discrepancies. Obviously, we know that cannabis is still federally scheduled as a controlled substance. That hasn't stopped it from being decriminalized in many states recreationally, let alone approved for medicinal uses. But there was some issues about prescribing, quote, the term prescribing. And so I believe that statute used different terms, ordering or I think it used the term recommending medical marijuana. So again, I don't know that necessarily addresses or answers your question or your concern about care plan. If not, that's something feel free to continue to discuss, but I just wanted to put that out there. Also, I did ask that Mr. Davis be promoted to the panel, so he now has the ability to mute and unmute himself and can chime in. And again, you can bounce any questions that you'd like off him. He is, of course, more of a subject matter expert on the Compassionate Use Act, as well as the laws that govern the individualized education plans and the obligations of schools to provide public education to students and the accommodations that are necessary and all of that. So, okay.
Question while we're teeing him up to speak. Of course, I do look forward to hearing our witness testify, but I'm wondering if maybe he could address how many cases a year we're really talking about. And also if he could maybe address if, the BRN precludes decision-making going forward with a precedential decision. And finally, maybe he could advise us relating to this precision of language issue. We'd really want to make sure we got it right, especially with state law and federal law being, in conflict.
Well, thank you very much to the entire board for hearing this matter and for your consideration. I can start with the clarification on the care plan term. Reza is correct. Certain students that qualify for IEP related services, they have an individualized educational plan or program. In some of these students' plans, the recommendation will be, for instance, the student needs access to medicinal cannabis in order to attend school. Right? And this comes into play where you have a student with, say, a severe seizure disorder who is requiring rescue intervention in the middle of the school day, and they can't attend if they don't have access to that medication. That's one portion. The second portion is for any student to have medication administered to them on a campus by school personnel, there needs to be a request submitted pursuant to the education code by the parent and by the physician. So the parent submits this a parent statement and a physician statement. In the physician statement, that's where the physician will certify that they're caring for the patient, that the patient is to take X, Y, or Z medication. It provides the route, the dosing, indication, counterindications, whether an untrained personnel can also assist in the provision of that medication. So we have a couple of set of documents. In this case, plus you may also have, particularly for the seizure patients, a seizure plan or protocol that lays out which medications are provided and at which times. In the case of the cannabis, you'll see a CBD to THC ratio, whatever it's going to be, 5 to 1, 10 to 1, administered at various points throughout the day, as well as some kind of rescue medication. So I've seen it in seizure plans, and I've also seen it in the physician requests for administration on campus. And in that document, in the physician statement, that's where you'll have the clear instructions for the nursing staff to follow. It says what's to be taken, when, which route, dosing, things of that nature. So that, does that answer the question on documentation? Or is it?
Thank you.
You're welcome. In terms of number of requests that we see, it comes up. I'm not going to say it comes up every single day, like a deluge of requests, but they happen, and they happen with enough frequency that it's caused some confusion across the state. I've been presenting on this topic with Stanford puts on a conference every year relating to cannabis and education, and it's attended by the county behavioral health folks, county office of education people, student services professionals. And the question that's been raised at this conference the last 2 years, and which came up in the case that was kind of the antecedent to this request being before you, is okay, it's all fine and good that we have the Compassionate Use Act, but these are students. I'm a nurse. I'm regulated by the BRN or the BBNPT, and I'm concerned about my license. I don't know which stance they're going to take. So the question is one that's active amidst the licensed community, and it's one that the schools are coming up against when they're addressing these situations involving students who have a right and a desire to access educational services, but are having to work out whether they can attend with their medication or not. So it is a relevant issue. It's coming up in districts across the state, and as we are getting back into in-person learning, I'm expecting this question to continue to pop up.
I'd like to chime in really quick. Additionally, our nursing education consultants have an ability to have questions posed to them by people contacting the website. and submitting an email request for answer, as well as calling our direct number, which then says if you have questions about a scope of practice, press a certain number and it takes you to a nursing education consultant. They receive questions on this frequently as well, on whether or not it's legal or illegal, or if they can and cannot do that. As part of this process, going through and working with legal counsel on this, it was shared that our nursing education consultants do believe that it falls under Business Professions Code 2725, where a nurse can administer any medication through any route as long as they're competent. And because the medical marijuana has been deemed a medication for these patients, that there is no wrongdoing of any of our nurses administering this medication as long as they are competent to do so. So I wanted to chime in and allow that, put that out there for you guys in this consideration as well, that over many years since the medical marijuana was approved for usage in California, not talking about when it was approved for recreational use, but for medical use, the BRN through the NECs has allowed for this to occur underneath BPC 2725, where the RN has the ability to administer medication.
Thank you, Lori.
So essentially, we're just clarifying that.
That's my understanding, Betty. We have, as nursing education consultants, as board staff, have made it clear that it would not be in a violation. However, there's still concern around that. Therefore, this ask for the precedential process.
Thank you.
Tricia, were your questions answered by Mr. Davis?
Much.
So we have a motion on the floor.
Betty?
I'm sorry.
We restate the motion.
Were you making a motion there, Betty, to say that it's not misconduct?
A registered nurse does not commit misconduct subject to disciplinary action when the nurse administers medical cannabis to a qualified patient student on a school campus pursuant to a physician's care plan, government code, blah, blah, blah. Yes.
Second that motion.
Okay, we have a first and a second. Any other comments, questions before we go to public comment? No? Okay. We'll go to public comment. BRN moderator, can you please open for public comment?
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, thank you. All right, we'll take it to a vote. Dolores Trujillo votes yes. Vice President Mary Fagan?
Mary Fagan, yes.
Elizabeth Woods? Elizabeth Woods?
All right. Woods, yes.
Okay, thank you. Imelda Sejapakowicz? Susan Naranjo?
Susan, yes.
Jovita Dominguez?
Yes.
And Tricia Nguyen. All right, the motion carries.
This is Lori, the board's executive officer. My board staff has contacted me and they're having a very difficult time hearing Betty Woods and was unable to capture that motion for note taking. Reza, were you able to get that full motion, or Betty, could you send that full motion via email? And if there's any way to work with your mic or put a headset on or move closer, that would truly help the board staff that are trying to take notes.
Do you hear me any better now? Is that better?
A lot better. Yes, absolutely. Thank you, Betty.
I'll read it over again then, if you don't mind.
Thank you.
A registered nurse does not commit misconduct subject to disciplinary action when the nurse administers medical cannabis to a qualified patient student on a school campus pursuant to a physician's care plan. And then there's government codes. Do you want those codes too? Or they?
That's not necessary. For our note takers, the motion tracks the language that's in the agenda item, just stating, instead of framing it as a question, stating a registered nurse does not commit misconduct. I was able to hear the motion sufficiently well when Betty made it in the first place. So I'm pretty sure that at least there was an understanding of what was being voted on.
Great. Thank you, Reza. That's very helpful. And thank you again, Betty, for working with your mic so that we can hear you.
I think I just had to put my computer closer to me. Thanks.
All right, moving on to item 6.0. This is the report of the Administrative Committee. Lori?
Thank you. Real quick before going over this agenda item, board moderator, can you elevate Matt Nishimi? He will under this one kind of speak about the fund condition as part of my executive office report. I'm going to delegate him to give the fund condition update. Thank you. Okay, so just some quick overview, just to let you guys know all the things that the board is working on. We will be meeting with DCA representatives next week on February 24th to get the report out from the Enlightened License Project. Just some update with that, or kind of bring that back to the forefront for all of you guys. That is where we partnered, the BRN partnered with DCA and had them come in and do a deep dive essentially and walk through all of our licensing processes and provide updates and guidance on how we can be more efficient. So, excuse me. We will get that report out from them on February 24th, and we'll immediately start implementing any of those suggestions that they give us, if that is at all possible. During this project, we have learned a lot. And as we've learned a lot, we've already started to update. So my hope is that we don't have a whole lot to do to continue to update, that we've already done it all and are well ahead of the game. But we will find out on the 24th when I hear the recommendations that came from the Enlightened License Project. Additionally, we'll move on to the California Grad Project. That's that licensing enhancement, one of those ideas that kind of came out of the review process for Enlightened Licensing process. We have worked with about 100 schools going through that process to get them to upload the license content verification. So in CCR 1426, we have requirements for education in order to be licensed in California. And that validation occurs through our deans and directors that are board approved. With that, working with DCA, working with OIS, and working with the contractor for IT that we got enrolled with us about a year and a half ago, they developed this California Grad Project where the deans and directors, as soon as they get degree confirmation, access that portal remotely, go in there, they query a list of all of their applicants, and based on that list, they then update with a graduation date, as well as a degree type, and hit submit. As soon as that information is submitted, we have validated the education requirements. Because our nursing education consultants have approved all of the pre-licensure curriculum, we know for a fact that they meet our requirements, and that allows us to do this. Additionally, because our nursing education consultants approve nursing program directors, we validate that they're giving us primary source data. They're not giving us anything that is false. And we have a working relationship with them. So that allows for that to be very secure and transparent. So with that, we just completed our grad season. That does happen in December. And with that, it's been a really great experience. A lot of positive feedback, some guidance on how they can improve this. And those students are, once that program director gets the degree confirmation, they access that portal, they upload it. It takes about 15 minutes for the nursing program to go through and update that. Some take as long as 30. And the very next day, that information is transferred to Pearson VUE, and Pearson VUE gives them their authorization to test within 3 days. Additionally, if they have applied for an interim permit, that is automatically released as soon as the authorization to test goes through, and that's that 24-hour time period, because we do upload and have our systems communicate at the midnight mark. And so it's a wonderful thing. If you look on our website, you can see that our processing times are under 60 days, and we're moving towards the 30-day mark. I will explain to you why that does take about a 30-day process, and you have probably still seen some outliers that are pulling our processing times low. We have students that are very excited to sit for licensure. And so what they do is about 8 weeks prior to graduation or 4 weeks prior to graduation, they come in and apply for licensure. There is nothing that we can do with those applicants at that point. We could process them and make them deficient, which will be the process moving forward. However, that has not been the process in the past because they are deficient. We don't have a transcript or an education verification from the program director. Once they graduate, the program director does have the ability to access that system on the day of graduation and do that. However, that would be making them a non-graduate RN if they receive licensure. Our students want a degree attached to that, and our program directors want a degree attached to that. So they have to wait for their academic institutions to process the degree, which means they need to confer the degree. As soon as that degree is conferred, they will access our portal and upload that information. On average, that has been taking the schools from graduation to degree confirmation about 4 weeks, 2 to 4 weeks. So depending on the size of the school, depending on the graduate requirements, understanding that each one of our pre-licensure nursing programs have a different curriculum. It's not a standardized curriculum. And so each one of those, it does take some time. So what we've been doing is a very big outreach with our nursing education consultants, with our program directors. I've also met with COADN and CACN to really encourage them to have the students apply as close to graduation as absolutely possible, because that is the start time for the processing timeline for us. Additionally, we've asked them to set some really real expectations of their students so that they know what's going on. If they say that, you apply and you'll get licensed by the BRN, then that student believes that it is on the onus of the BRN at that point. But we've been working with them to get the message out that is, we will upload your information as soon as you get we confer your degree. And that takes this amount of time at our institution. And that way the student then has an understanding that I'm not going to see anything move on my application for 4 weeks because that's how long my school takes to confirm degrees. Additionally, we've asked them to have conversations with their transcript department to see if they can prioritize the nursing students. Remember when this first started in conversation back in August, moving to this method, it was about expediting this for our applicants so that they can test with Pearson VUE within 3 months of graduation. That's the key. Once we release the authorization to test, Pearson VUE typically gives them that information within 3 days, and then they have to schedule their exam. That exam can be scheduled out 2 weeks. It can be scheduled out 2 months. That is dependent on Pearson VUE's availability and the student's availability to test. So working together, we're hoping that the schools can prioritize the conferring degrees so that our board approved director of nurses can access this site as quickly as possible. We're hoping within 2 weeks of their last date of attendance, and upload this, because now the only limiting factor is how quickly the school can confer degrees. And that will dictate how quickly that program director can upload this validation through our system. Once we've received the uploaded validation through our system, we process it within 24 hours. So there is no further delay on the BRN part. And then the interim permit is an automatic process. If the student applies for the interim permit, that interim permit is issued at the issuance of the approval, the authorization to test from our board going to Pearson VUE. So that has been automated. That should really help getting our new grads out into the workforce as quickly as possible. And the BRN will no longer be a hindrance, be seen as a hindrance to that. And it should go quickly. With the fund condition, I will defer that to the end of my executive officer report, where Matt Nishimi will go ahead and give an updated information on that. On the CSA update, we're continuing to work on the 5 areas of recommendation that have been outstanding, and that is working on the clinical facilities approval data bank. We also had the passing of AB 1015 that became effective January of 2021, where that updated our Business and Professions Code 2717. Business and Professions Code 2717 now requires the BRN to collect clinical data from all healthcare facilities, whether they can have students there, how many students they can support. This is a huge change. Please understand that the clinical data that the BRN has had access to in the past were there because of a contracted agreement between academic institutions and that healthcare facility. That is not what is the requirement now. This is a requirement for BRN to collect possible clinical placements that are not necessarily already in a relationship with a student. So we will be working with California Hospital Association. We will be working with California Department of Public Health, with CMS, to really see how we're going to get that data and how that data will be published to our website. When we were going through the implementation of working through these recommendations from CSA, we had updated our clinical facility approval form to collect this data, and we did start a regulatory package update that would update CCR 1427, the clinical facilities approval. That package is with OAL right now and is going through that process. We did have a hearing set for that in January, and we're continuing to move through that process of implementing this. And that will assist with getting the processes in place, the IT support, the build, all of this information out to the public. One other thing to take into consideration when we're doing clinical planning and workforce planning underneath BPC 2717 is that you can't have more students if you don't have clinicals. You can't have more clinicals and more students if you don't have faculty. So the other part that we're working on with IT right now is tying the faculty approval to the RN license for a license lookup in Breeze. We're really trying to follow the regulatory guidance that we already have in place and make it efficient for our program directors. The current process for faculty approval for our program directors is that each school that the faculty go to, they receive a separate faculty approval from the BRN. That is time consuming, and sometimes a delay occurs, and maybe that faculty that wanted to go to that school will accept a job offer someplace else. That is not something that we want to continue to do. So we will be tying it and mirroring as closely as possible to teacher credentialing that happens within our state, where you get a teacher credential one time. You don't have to have that updated every place that you move. If you teach, if you're credentialed through K through 12, and you have a single subject credential, you can teach that at any school that wants to hire you within California. You don't need to get reapproval each time. And that is the process that the BRN is looking at, which follows our regulatory guidance already and does not require a regulation update for that. So we will be tying that to Breeze, to the RN license lookup, and they will have a faculty approval, which would be very similar to a teaching credential. And that would have an expiration date of every 5 years that they would then renew to show recency. Our recency requirement is a 5-year, and we would abide by that. That would then allow us to take and create a data bank. What we're doing is creating an interactive map of California that will be shared on our website. We've been talking a lot today about website updates. That is what is happening this year, a lot of website updates. With our website update, we plan to show the location of every single pre-licensure nursing program within the state of California so that you as a board have an understanding of where your schools are located and what regions they serve and whether or not they're serving some of our more rural areas, whether or not they're serving the areas that have workforce impact, either excess or not enough. That will then show a year-to-year update. That year-to-year update will have enrollment information of each one of our pre-licensure nursing programs, so you can see whether or not our programs are having growth or whether or not they are declining in enrollments. This is something that you guys have been asking for to make informed enrollment increase decisions, and we're working very hard to get that out to you. In addition to having a map that shows where the schools are, the enrollment numbers, and the growth or decrease from year to year, the plan is to take the faculty information, because it's tied to the Breeze license, that has an address of record that's assigned to them. So we will be showing where faculty are in greatest concentration or a lesser concentration on a regional level throughout the state as well, so that our directors of nursing can recruit, can understand where they're at, where decisions can be made to new RNs. In this, I wanted to share is you guys have worked hard on enrollment increased, new program approvals, as well as feasibility studies and new campus locations. In California last year, our board approved 6 new programs, adding 506 new student slots to California. 4 new campus locations, adding 580 new student slots to California, and granted 14 enrollment increases, adding an additional 371 new slots to California. I need you guys to understand that's an annual number. That is not a programmatic number. So that is 1,457 new student slots throughout the state of California that can be added to our already approved numbers going forward. We do have on our agenda for today more enrollment increases and new campus locations, so we're continuing to grow. In addition to the programs, the campuses, and the enrollment increases, the board also approved 5 new feasibility studies that would add 264 students into the annual number, understanding that the feasibility study is where the program has provided the documents that says they have the ability to develop, implement, and sustain a viable pre-licensure registered nursing program. You guys have approved 5 of those, so there'll be 5 new nursing programs coming forward in this next year, where they will complete the self-study component of that, where the NEC goes out and says, you have complied with all board's rules and regulations, you can now enroll students. Additionally, I went back and looked at 2020. In 2020, in the height of COVID, where program directors were really having a very difficult time finding clinical placements, the board approved 1 new program, 1 new campus location, and 2 enrollment increases. which added to the student slots 282 that year. In comparison to what you guys did this year with over 1,400, that's quite a huge increase. And then in 2019, prior to COVID, you guys had voted in 3 new programs, 5 new campuses, 4 enrollment increases, that's 770. So prior to COVID was 770. And then just this last year, you guys doubled that to 1,457. There has not been a single enrollment increase, new campus location, new program denied by our board since 2019. And I think that that's something that you guys really just need to kind of look at when we're looking at workforce and going through the implementation of AB 1015, which is now BPC 2717, where we need to address workforce needs, including shortages, and bring that down to a regional level. So the board has been been working really, really hard trying to ease the workforce strain over this last year. And I think that we're on the right path with the addition of almost 44,000 new RNs into California to help in the last year. That is it for my EO update. So I will at this point pause, answer any questions that you have specifically for me. And if you guys do not have any specific questions to me, I will open up to Matt Nashimi to give an update on our fund report.
I have a question. Thank you for that report. And really, there's so much positive going on. I really appreciate all the work that's being done to really streamline processes and give us the information we need to make informed decisions. One of the things I wanted to ask about is the 43,000 new RNs that came by endorsement. Do you have information about how many of those were possible based on the EMSA waivers versus had they gone through our typical process?
That's actually a really easy question. Of the 43,000 new RNs, 26,100 were endorsement. So just to clear that up really quick, none of them were affected by the EMSA. The EMSA waiver is completely separate from the Board of Registered Nursing. That ability for an RN to come in from out of state working under the provisions that were provided through EMSA are specific to that state agency and does not have any effect on BRN California licensure. The 26,100 endorsement applications were people that wanted to come and work in California through the BRN getting a traditional license. It is not a temporary waived license that fell under the provisions allowed for EMSA. EMSA's provisions were completely separate from BRN and are separate from our numbers.
So do we know how many nurses were able to come and work in California as a result of the EMSA waivers that the BRN really didn't interact with?
I can get that report from you. They did send me, I believe, about a quarterly report that told me a list of them. The thing with that report is it captures all RNs coming into California, and it doesn't separate them out and remove them if they received licensure through us in California. So there will be a duplicate count, and I have no way of teasing out that report to give you an accurate number. The way that EMSA chose to report that was just anybody that came in was sent over the BRN so that we knew that they were working in case we did get any kind of enforcement complaints. We did receive enforcement complaints on EMSA approved nurses where they were removed from California, and we did open up complaints and let their license state know of the complaints that were received against their RNs.
Thank you. I do know just from our experience here in San Diego that the vast majority of the traveling nurses who came with EMSA also applied for licensure by endorsement.
Yes, and so that makes it a very difficult to kind of tease out that report to say which one came in solely on EMSA and which ones came in solely through RN endorsement.
I think EMSA probably just expedited a lot of them.
I think so. Yes, I think there was a really big misunderstanding at the beginning where people were not aware of our temporary license. So with this bill for sunset last year, one of the requests and was put into that bill and then ultimately passed into law was for us to add a temporary license button to our homepage, which we did. and we've done a lot of outreach, letting people know that we have an option for a temporary license. That option for temporary license allows for a person to be licensed in California sooner than if they go through the endorsement process, but it is tied to the endorsement application. So you will come in from out of state, apply for your endorsement application. Once that application is completed, you would pay $100 for a temporary license. That license can be issued once we receive your application and get a clear background. And we verify that you have an active license that's clear in other states. And so that expedites the process and allows an RN to come in and work here on a temporary license while they're waiting for their education materials to be reviewed. In CCR 1426, we have educational requirements that are for licensure in California. That requirement is met by applicants submitting transcripts. We do only take primary source data. So it's a transcript that comes from Parchment, from, what's the other one? Clearing Warehouse, I can't remember the initial name, or directly from a school. With that, we then take that transcript, every transcript that they may have had in their pursuit of their nursing degree, and we review that to see if it meets the licensure that's the education required for licensure that's set out in 1426. That is time consuming. The transcripts that have to be sent and downloaded and reviewed and uploaded, and then sometimes we find out that their education did not meet our requirements for 1426. We don't want to deny licensure for that. We want them to have the ability to work while they're making that information up. And that is done through that temporary license. They can get that temporary license for 6 months. While they're working on that temporary license for 6 months, they can complete any of those outstanding course requirements. Some of them as simple as a microbiology with lab. Some of them maybe something more. And if that comes up, they also can apply for an extension to that temporary license, which would grant them additional 6 months, totaling 12 months that they can be here working on a temporary license while they are getting their education reviewed or completing any additional education requirements that are needed. And so that is something we really worked on outreach, getting that brought forth to our homepage on our website to be in compliance with that bill that passed. That was our sunset bill.
Any other questions or comments?
Madam President, I have a quick comment.
Sure.
I just really want to thank you, Lori, and congratulate you and staff for, working so hard to create efficiencies for nursing and, to provide, better care for California's patients during this really difficult time. I'm just super impressed when a bureaucracy takes it really seriously to remove obstacles and still provide protections. And I just want to commend you for your hard work.
Thank you so much. The blessing that happened for me, I believe, is I came in February 20th, right before COVID hit and broke out. And so it was fresh and the need was present. And so hitting the ground running to find any efficiency that we can possibly have to supplement and support the workforce was primary. Our board started with emergency regulation, started working through that process and really made that a primary focus. And all I did was follow what they wanted. So thank you very much. My staff is amazing. I remember meeting with the deputy chief of licensing and we were talking about processing times and they were pushing the 90-day mark, which is our statutory requirement to be under 90 days. And we kind of went back and forth and said, what is the best that we can do? And that was 60 days. And that was not in a grad season. And to understand grad season, that is a winter grad season and a summer grad season. So that takes about 6 months up of our year, where we would push the 90-day mark and then we'd get better in between grad seasons. And we said, well, what can we do to make this faster? And she worked with our team of IT, with the chief of licensing, my assistant executive officer, myself, and just a huge amount of staff at BRN and DCA to really get these efficiencies going. And I'm excited for next week to hear about the Unlicensed License Project And we are told that some of our updates will be used in other boards. And so we're happy to kind of lead the way in some of those areas.
I just want to commend you and staff. This is way overdue. We've come a long, long way, and thank you for your leadership and your staff. This is awesome. You know, we're moving forward. We're making great progress here. And again, I just want to thank you and the staff.
Thank you, Imelda. Thank you, Tricia.
Any other comments or questions? Lori, do you want to move on to the speaker?
We'll actually have Matt Nashimi report out. Matt Nashimi is going to give us an update on our budget. He is he's been promoted to panelist, and he can unmute himself and talk about how the budget stands for BRN.
Thank you. Matt?
Thank you. Thank you, Ms. Melby. My name is Matt Nishimini. I'm in the budget office. I'm also in the regulatory unit. I'm also here today with the budget manager, my colleague, Renee Milano. So if you guys have any questions, please ask. I don't know if we have a display of the fund condition statement that was presented, or is it in the board members packet? I can go over that.
It is not. I had to take 2 days off for bereavement leave on Monday and Tuesday, and so that was not put forward. I will get that added to the materials within 24 hours.
Okay, so, well, the good news is that we can just go over it without a display. So I will say that the board is in very good financial shape. Revenues are projected in this current year of about $75 million. And your expenditures are quite a bit less. Total are about 60 million, a little over 60 million. So you're structurally balanced where you're bringing in more revenues. You've got a nice healthy reserve balance at the end of this year of 9.3 months. And that will continue to grow, projected to grow. There's also a $30 million general fund loan that was provided to the general fund last year. So if we add that back, you're even healthier. So the board is doing a very good job of spending within its budget appropriation, and everything looks good. Revenues are coming in as we anticipated, and they're actually spending a little less than we had budgeted. With that, I can answer any specific questions that you might have related to your budget.
Any questions or comments to the budget, regarding the budget?
I have a question, Matt. Is there a point at which if our revenue or our reserves are at a certain level that we actually would look to have to reduce charges for licensure or any of our other charges?
Yes, I believe the statutory cap is 24 months or 2 years. So we're at we're in the 9 to 10 months range now. And then if we add back the $30 million, I think it takes it up to about 13 or 14 months. So you are below your statutory cap at this point. I would say this, that we are projecting that expenditures will go up to the extent that the board fully expends its appropriation. The appropriations do increase year over year, and you will be trending, that structural imbalance will be trending more towards zero, or structurally balanced will be trending more towards zero. So I think we're just in a wait and see before we start reducing fees at this time.
And then we thought there was going to be some reduction in revenue from transferring to the nurses program for validation of license for California nurses who go to other states. Did I understand that correctly?
That is correct. I don't know that Matt is aware of that yet, because he's outside of BRN. So we are currently in contracting with NCSBN to utilize nurses as our license verifications. Prior to that, we received a fee for every single verifications request. That annual was about $2 million that we received in revenue for that process to be done and processed through our board. So once we do finish these contracting, following that board vote in November to move to nurses, we will have a decrease in $2 million a year for revenue. And truly that's an okay thing for our board, the way that we stand right now with our fund condition and the way that it really provides for greater efficiencies and aligns us with all other boards of nursing throughout the state.
And it should reduce our expenses to a certain degree as well, right?
Yes, absolutely.
People expenses of having to do that manually. Yeah, great. All right, thank you.
Any other questions or comments from the board?
Great. Lori, how many vacancies do you have? And is some of this revenue due to vacant staffing?
There is some vacancies here, and it is due to some vacant staffing, but it's also due to a lot of other things that are going on. We have staff that are entry level, and they'll come in, they'll take a position, they may move to another board. So it's not that we haven't filled those vacancies. We've filled them. They just kind of rotate through that. They also use this as a stepping stone to promote within. We do promote a lot of our staff within. And so we will then fill another position by vacating one. So it's almost like kind of musical chairs. It's an interesting process to watch. We do have NECs that are vacant right now. We do have a lot of NEC vacancies. That is our most difficult position to fill, and that does come down for educational oversight, Goal 5, laws and regulations, Goal 6, organizational development, and Goal 7, outreach. That was shared to our website. We also tied our SLAY report to this as well. We updated mission and vision, and this will serve as kind of our performance tracking project overview process as we move into these next few years. We are only a month in, and so with a month in, we don't have much of an update other than we are aware of these. We're starting on most of them, and I hope to have a better update for you guys going forward at our next board meeting when we're further along into starting this process.
Thank you, Lori.
Thank you. And then real quick to answer Mary's question about the EMSA, the last report that I had about 2,300 RN, 23,000 RNs that had come in through EMSA during COVID. And I cannot differentiate out how many of those 23,000 have sought licensure with us that would contribute to the 26,100 that we brought in through endorsement.
Thank you, Lori.
Yep, thanks, Lori.
All right, if there's no more questions or comments, can we open it up for public comment, please?
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Barbara Miotti would like to make a comment. 1 second, please. Barbara, go ahead and unmute yourself. Go ahead, Barbara.
Okay. Hi, I'm Barbara Miotti. I'm actually the Assistant Director over at Golden West College, as well as a full-time tenure faculty member. I've been teaching now for 16 years at Golden West College. I want to make a comment as a clinical faculty. I do bring students to clinical, and I have seen changes over the years that are disturbing to me. More than often, when I bring students to clinical settings, I find students from other schools present on the units. So this causes me to actually stop what I'm doing, interferes with my students' learning, as I have to find what other opportunities are present. So this is concerning to me, as I'm hearing that there's another school that's, I believe, about 4 miles from our present college that wants to come and open up a program near us. I have grave concerns regarding, how that will affect our students' learning. We are a community college. We serve the public, and we serve basically underserved areas, right? So I have grave concerns that people that can afford to pay out big bucks to get a nursing degree are going to take over the spots of students that may be first time coming out of an underserved area, which we need those students to become nurses, right? So we can increase diversity into the clinical setting. So it's very, very disturbing to me on multiple levels. I do work with our dean to try to find faculty as well as facilities, and it is a constant struggle. So I at this point, I do not feel that's appropriate to bring more clinical sites into the Orange County area because the area is already stressed enough. And so I just wanted to voice that opinion out to all the members there. It's going to get to the point, these privates take over, that we're not going to have community nursing anymore. And that's going to really limit some people in getting a good nursing education that can increase diversity once they become nurses, as well as what's needed for the nursing profession. So it really just concerns me. So I just wanted to say my little thoughts on that. So thank you very much for listening.
Thank you very much. Just a reminder that the enrollment increases and such will be discussed underneath the Education Licensing Committee meeting, and they have their own agenda item. And if you feel very, very strong, I would recommend that you stay on, and that when that school that you're referencing to, or that area or regional area that you're referencing to, is brought up in those enrollment increase agenda items, which are new campus location, new program approval, feasibility studies, acceptance of self-studies, as well as just the traditional enrollment increase to an already approved program, that you make public comment at that point. That is where it would be beneficial to hear. Thank you.
Oh, okay, I'm sorry, Loretta.
No, don't be sorry. We were talking about enrollment increases here, so it made sense, but it would really have a greater impact once we get to those agenda items. Thank you.
Karen Lightfoot would like to make a comment. 1 second, please. Go ahead, Karen.
The School of Nursing at Chico State, and I'm also the president of the California Association of Colleges of Nursing. And I just wanted to acknowledge and thank you for the process improvements you've made with the licensure application. That was very helpful for our students, and we appreciate that.
Thank you. Mary Steckler would like to make a comment. 1 second, please. Mary, go ahead and unmute yourself. Ms. Steckler, go ahead and unmute yourself. Board President Trujillo, our last person who wishes to speak, either has left us or cannot unmute themselves. She is the last person. Would you like me to close this window, or would you like me to try her? You have to press, I send the request and you have to okay it.
That's okay. We'll close the window. Okay, moving on to item 6.2, discussion and possible action regarding moving the April 21st, 2022 committee meetings to March 17th, 2022, and delegating authority to the administrative committee to revise the established board and committee meeting dates if necessary for the remainder of the 2022 calendar year. Lori, do you want to explain this?
Thank you, Dolores. Yeah, I'll go ahead and open this up and start a discussion around it. So there were some provisions that were put forth by the governor that allows us to meet remotely. Those provisions end at the end of March. We do not have a committee or board meeting scheduled for March at all, but we do have a committee meeting scheduled for April. And by working with board staff, by meeting with some board members, the requirement to travel may be difficult. And finding an in-person location, securing that may be difficult as well. So what the ask has been is to consider moving the committee meeting that is scheduled for April to March instead of April. We would keep our board meeting scheduled for May, as we do have a statutory requirement that we hold board meetings every 3 months. And so we're here in February having a board meeting. And so March, April, May is our third month. And so we cannot move the May board meeting. That has to stay there because that is required in statute. The ask was to consider moving the April meeting to March so that we can do the committee meeting remotely. There is some drawback that I do want you guys to take into consideration when making that decision. The largest part of any of our board meeting has been and probably will be the Education Licensing Committee meeting. That is the part of the committees where our school directors and our school programs and potentially new programs all come in and present items that need the board to take action on and to hear them. The deadline for that would be now, essentially, in order for them to be able to move their content to March. So that may be very difficult for some of our schools to meet. If you guys do decide to move the April meeting to the March meeting, I would like to ask of our board an understanding, as many of those schools may go directly to the May board meeting so that they do not experience any delay. That what that means to you is that you will be hearing them for the first time at the May board meeting versus hearing them in a committee meeting and then voting on that committee meeting recommendation in the board meeting. It would then allow for those schools to not be impacted, to stay in alignment with the May board meeting as they have been in alignment with. It would just require a little tweak to our typical process in order for that to happen. Understand that that would typically mean it would be a longer board meeting as well. But it would give us the provisions to be able to meet remotely for the committee meetings. There are some schools that have turned in their stuff. They are aware of this. Our NECs are working very diligently with them, and will do everything in their power to get them through here if this vote is there. All other committees should not have a big impact. Nothing like we may see at the ELC committee, but there would be changes, of course, in the legislative process, because we do have a leg committee that has bills that are, watched and tracked. And so we may, again, have a little bit of a change on that, which would not be problematic because we do take a whole board position, which that would not change, and that would occur in the May meeting. So hopefully that helps to give you some background as you guys do discuss this. I can tell you that board staff and I do support the moving of the meeting from April to March, and we would support going through the process and working with our program directors to ensure that they do get the timely representation that they need and require, and that they will continue to all go to the May board meeting, with the exception of going to ELC if they are not able to get the materials to us in time.
Thank you, Lori. Are there any questions or comments from the board members?
Any possibility that the governor is going to extend the authority to have the committee have meetings remotely?
My fingers are crossed, my toes are crossed, my eyes are crossed. We're hoping. We just really have no way to predict what the governor is going to do. The governor does have the ability to do that. We have not heard anything that it has happened. There is a bill that is introduced. It will be discussed in the legislative section of this one, that does make changes to Bagley-Keene that allows us to go in person. But it hasn't been passed through. It does have a clause on it that allows it to be implemented immediately, with I think it's a 2/3 vote. But again, that's all kind of still to come. So when working with DCA and meeting with everybody, they have recommended that we prepare for in-person meetings while we wait for that bill to hopefully pass.
I have a conflict that I wouldn't be able to move that's between 11 and 1 o'clock on that Thursday. And I'm a member of 3 of the committees, so that day does not work well for me.
That doesn't work well for me either. I'm going to be on an airplane at that day. 24th or 31st would be okay.
Lori, would there be an exception? I mean, could we do another date rather than March 17th?
Yeah, if there's another date that you guys would like me to look at, we can absolutely look at changing that if there's a better date for you guys in March. We just went with this typical convention that we go I think the calendar has been made where we do every, I think it's the second Wednesday, Thursday, I believe, or of the month. And so we just tried to stay in alignment with that. But absolutely not an issue. If you guys want to decide, you can now, but as part of the motion you could make when you guys are giving the authority, if you guys choose to give the authority to the admin committee, I could meet with Dr. Fagan and Dolores and come up with a meeting date that would work for everybody, and we could send that out to the board members and see if we can get a quorum. Very similar to the way that we handle scheduling meetings that aren't regularly scheduled if we're not able to come up with a date during this particular agenda item today. So we do have some flexibility for this if you guys do make a motion for that.
Okay. I would like to make a motion that we move the April 21st, 2022 committee meeting to another date. I'm just wondering how I'll phrase this. Another date in March, which will be discussed and decided with input from the board members. Yeah, so we can look at another date in March, but for now, moving the April 21st, 2022 committee meeting to a date in March. Is that enough for a motion, Reza, or do I need to expand it a little more? Reza?
He's off mute, but I'm not hearing him.
Could give authority to the executive committee to find a date.
Yes.
In consultation with other board members.
Can you hear me now?
Yes, we can, Reza. Thank
Okay,
you. And yes, Trishna, that's exactly the ask. Thank you.
That's the ask, Tricia. Thank you.
And that's exactly what I was going to suggest. I apologize. My earbuds battery died, so had to switch settings in WebEx. Anyways, I was going to make that suggestion that rather than that, you can just state the motion as delegating authority to the administrative committee to work with board staff to revise the currently scheduled April date for the committee meetings to a date that works for a quorum of each of the committee members. And that way they'll work with board members offline, of course, minding the Bagley-Keene communication requirements to land on a date that works for enough of you and allows us to meet remotely, of course, given the uncertainty that we're operating under with how things will look a couple months from now.
If that's your motion, Dolores, I would second that.
That is my motion. Thank you, Tricia.
Mm-hmm.
Any other questions or comments from the board members before we go to public comment? Okay, seeing that there's no further questions or comments.
I'm sorry. Oh. Dolores, I apologize for the interruption. And this is, I guess, for both you and Tricia. Noticing that part of the agenda item is not just related to the April meeting being moved to March, but also considering whether to delegate that same kind of authority for the meetings for the rest of the year. I may suggest just amending the motion if you are so inclined to so that it's not just limited to the April meeting, but the rest of the meetings for this year. And those of you who've been around may recall we did something like this previously with COVID and the possible need to kind of move meetings around if necessary due to circumstances. So if you're amenable, I might suggest amending the motion to more broadly apply to the rest of the meetings for this year.
I do. We would not set it in stone unless we had also board member input. So,
thank you.
Yeah. So yeah, we could open this up for the rest of the year. And we would not set in stone without board, we would not set the date without board member input.
Okay, so maybe the revised motion might be to
make sure that board member input is in there somehow.
Okay. How about to delegate authority to the admin committee to work with, to have authority to move meetings by working with board staff who will consult all of the board members in connection with a possible revised meeting date.
Sounds good, Rosa. Thank you.
Good. Thank you.
Tricia, do I still have a second?
Yes, thank you.
All right. Let's open it up for public comment.
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for a comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, thank you, Mark. All right, let's take it to a vote. We have a first and a second on the floor. Dolores Trujillo votes yes. Vice President Mary Fagan.
Mary Fagan, yes.
Elizabeth Woods.
Woods, yes.
Imelda Seja-Bukowitz.
Yes.
Susan Naranjo.
Susan, yes.
Jovita Dominguez.
Yes.
And Tricia Nguyen.
Tricia Nguyen, yes.
All right, motion carries. Moving on to the next agenda item. So we did 7.1, 7.2 earlier in the meeting. We are now on to 7.3. Betty?
Discussion and possible action regarding naming conventions for nurse practitioners practicing pursuant to standardized procedures and pursuant to business and professional code.
Betty, again, you were a little hard to hear.
Okay.
Sorry. Thank you.
I don't know what it is, but I'll try again. We're going to be discussing in a possible action regarding naming conventions for nurse practitioners practicing pursuant to standardized procedures, pursuant to business and professional code sections 2837.103 and Lori, are you going to be leading this discussion?
I am. I'm here and I will present for you, Betty. Absolutely.
Thank you.
So this was referenced in Samantha Gamble-Farr's, the chair of the Npac committee's report out on 7.1. And this will kind of give you an update on this one here as well, so we can kind of go more in-depth conversation. This was presented as part of an agenda item to the Npac with some suggestions for naming conventions for them to kind of hear, consider, take a vote on, or present something completely different, which is actually what they did. They presented something completely different. So we did a social media outreach when we were starting the regulatory update. It's not update, sorry, the regulatory writing for the implementation of AB 890 to see how the public would better understand the difference between the 103 and the 104 NP. We've been referring to them as 103 and 104, and the nurse practitioner community has been referring them to 103 and 104 just to kind of go through the process of implementing AB 890. But 103 and 104 is not clear to the public as to what this means. It's not clear to an employer as to what this means. The makeup of our Npac committee is 4 nurse practitioners, 2 physicians, and 1 public member. That public member happens to employ nurse practitioners as well. And so it was wonderful to hear all of the input from our Npac committee. Some of the suggestions brought forward really kind of focused on location. There was discussions around nurse practitioners have been practicing, Betty gave an example of almost 40 years. And those nurse practitioners that have been practicing in the state of California have always operated under a physician through standardized procedures. Those standardized procedures allowed them to work in the realm of medicine. That was the only ability that they had at that point. And the thought was that the nurse practitioner name should stay with those types of nurse practitioners, the ones that still had to operate under standardized procedures with a physician. So that was put forward as one suggestion. The next suggestion for the 103, what happens with the 103 NP is that if they've worked for 4,600 hours, equivalent to 3 hours of full time, and if OPES decides that an exam is needed and they've completed the transition to practice, that they can work without standardized procedures as long as they're located within a healthcare facility or within a group setting. And so some of the suggestions that came through would be nurse practitioner, independent nurse group setting, or nurse practitioner, independent healthcare facility. So those were some of the suggestions that were kind of garnered and tossed around, came from BRN staff, came from external stakeholders, and we put that forward to the Npac committee. Additionally, with the 104 NP, the thought was independent private practice, because the 104 NP can operate independently within their own private practice. Discussion at the Npac committee said that that was too confusing, that that's not the naming convention that they wanted to go to. And in fact, the Npac committee voted to keep nurse practitioner as the naming convention for all three of them. For the nurse practitioner that graduates from college and is working underneath a physician with standardized procedures for the first 3 years, or the nurse practitioner who decides that they want to stay in that role and not to advance to a 103 or a 104 independent level. Then they said that the 103 NP should stay as a nurse practitioner because they felt not a lot of differentiation for the public at that point, because they're working within a healthcare facility, they're working within a group setting, they're still working with colleagues very closely, they're monitored, etc. And so they felt that there was not much of a change between the nurse practitioner and that chooses to stay under standardized procedures, or the nurse practitioner that's working within a group setting. So the real one that they wanted to put emphasis on was the independent nurse practitioner, and that's the naming convention that they have chosen, and that's the independent nurse practitioner, and that would align with the 104. And the discussion around that was, as Samantha Gamble-Spar shared, they have an alphabet soup after their name, just a ton of various lettering that a nurse practitioner or a physician or a hiring body, would know and understand, but maybe the lay person wouldn't. And so on taking that into consideration, on listening to the same public comment that you heard here today was heard by the Npac committee. There was a lot of conversation that went around about the nurse who specializes that direct translation from the English to Spanish. And there was a lot of conversation around that, whether or not that should be taken into consideration. They said that vocalization of that still occurs, whether we put a naming convention on this or not. That is required in statute. That vocalization will occur, and that interaction with the patient will happen. What was really wanted to be addressed was hiring and people that are doing license lookups. And so a person or an organization that wants to hire an NP wants to know legally what that scope of practice is for that nurse practitioner. And because there is now a pathway to independence and is not standardized like a midwife that has only one type, they said, where can we go to find this? And we said we can add that to our Breeze license lookup. And so even if they choose not to use a different naming convention, we would have this on our website, look up, that if they put in Elizabeth Woods and checked on her nurse practitioner certification, it would say that she was active and she didn't have any legal actions taken against her. And there would be a caveat that would say that she is a nurse practitioner that would operate under standardized procedures. Once she completed the transition of practice and submitted her paperwork, it would then say Elizabeth Woods is a nurse practitioner who has an expanded scope of practice to include BPC sections 2837.103. And then ultimately, once Betty did her 3 more years as a 103 NP and stays in good standing, she would then transition to a 104 NP, and that would be noted on the Breeze license lookup that she is an independent nurse practitioner. We also have her category of nurse practitioner in there, whether or not she's a pediatric nurse practitioner or a women's health nurse practitioner or a family nurse practitioner, that would be located there, because within subsection 104, it requires you to be independent within your national certification, which is that category of nurse practitioner. So we would have that on our website. It would be very clear to the employer. It would be very clear to people that would look up. It would link to the statute so that they can read that if they chose to, but it would not interfere with the adding additional letters behind the name, with the exception of the 104, where the Nurse Practitioner Advisory Committee thought it would be best to call them an independent nurse practitioner that may potentially be abbreviated as INP. Right after their name. They may choose not to abbreviate it that way, and that's perfectly fine as well. Understand that when the board is considering this and talking about this, that the Nurse Practitioner Advisory Committee gives recommendations, and that the board can vote in a manner that is in alignment with those recommendations, could suggest something different than that, or can vote completely separate from that. They're serving only in an advisory position. So that is where we're at right now. And I'll open it up to board conversation, board questions, and I'm available if you need anything more from me.
Well, I think I gave some of my concerns about it before, but I'm even thinking of it more now. And I don't think there should be any name after the nurse practitioner. Whether you're independent practice or not is a different, to me, that's almost a legal thing. I think it's confusing to put independent after a nurse practitioner name, because then you question, well, what about these other nurse practitioners? Is this one better than those other ones or not? And as far as nurse practitioners go, you can be certified in many different areas if you choose to do that. And you also can be nationally certified if you choose to do that. Right now, it's not a qualification for being a nurse practitioner in California. If the employer wants that, well, then that's another whole story. But I'm trying to make this as simple as possible. If somebody wants to practice independently, there's a way for them to do that. They go through a whole process and they become independent. Maybe they want to set up their own practice or something. They don't choose to do that. I don't think that's a reflection on whether they are a more advanced nurse practitioner than someone else is. It's a choice that people are making whether they want to be independent or not. And I'm not sure that that is something that we should have to bring the public involved in it. If they want to know about that, the public can always ask about it. And I'm telling you, my years as a nurse practitioner, nobody even asks about what a nurse practitioner is anymore. But I want to make it as simple as possible and not overcomplicate this whole thing. And I'm very, very glad that there's a way to be an independent nurse practitioner. But I don't know that we have to bring that to the fore to such an extent that we have to put it on the licensing, not that we have to put it on our name tags, that So I'd like to hear some other people's reaction to this. So that's my reaction as a longtime nurse practitioner. And I hope everybody heard that, because I know sometimes don't hear me.
We did hear you this time, Betty. Yes, much better. Thank you. So my understanding from you is that the Nurse Practitioner Advisory Committee voted to do independent nurse practitioner for 104, but have no naming convention for the nurse practitioner that is operating under standardized procedures or in the 103 section. And so your ask or your suggestion is to not have any naming convention at all. And the only reference back would be on the license lookup when they would say that they can practice under the 103 section or the 104 subsection. Is that correct, Betty?
Yes, to a certain extent. I'm not against having it on the board, the licensing part, but I'd like to eliminate it entirely. I don't like the word independent because it makes other ones seem like, well, they're not as the qualifications to be a nurse practitioner, and I certainly don't like the one specialized, because people can be specialized in a lot of different areas depending on what types of certifications and that they have. It has nothing to do with being an independent nurse practitioner or not.
I'll chime in here, Betty, and I certainly agree with you about the term specialized. I don't think that would serve the public well in any way, nor the profession. And I'm sort of torn about whether, I mean, this whole legislation was about the independent practice of nurse practitioners, right? I mean, it was to try to get nurse practitioners out in underserved areas where they could actually hang their shingle and take care of patients who are in need. And so you don't have to have a separate name to do that. So, and if this is going to cause so much controversy, what we would just be able to identify is who is capable of practicing with who requires standardized procedures and who does not.
Exactly.
And it may not have to be in the name. It could just be in the way that we're able to look it up in the BRN. So I could go either way on the independent versus no, but I really don't think specialized is helpful in any way.
Any other comments or questions from the board?
As a public member and potentially a patient, I'm like totally confused. So that's just my comments. Thank you.
Yes, I mean, it's adding another whole layer of confusion as far as I see it also. And patients go to nurse practitioners all the time. Nurse practitioners are not new. This is not like we're inventing a new nurse practitioner role. It's been around there for a long time, believe me. And I don't want to be adding more confusion to it. I think it's a legal thing more than anything else, that you only can practice independently if you jump through these hoops. And that's fine. I have nothing wrong with jumping through the hoops. But I don't know that we have to bring it to the point where people are going to start questioning and independent versus non-independent. And I think it's confused the whole issue here.
Laura, you might have this information. I wish I would have asked Samantha. I don't know if she might still be on, but what other states that they have similar legislation, how they've approached the naming convention would be helpful to know.
Just in conversation is that it's just considered a nurse practitioner, that there is not a specific naming convention. Some states do not have a stepped process like we do. So we are still unique to some states because of that stepped process into this practice. So I don't know that we can be identical to do that, but I think similar enough that our Nurse Practitioner Advisory Committee wanted to make it in alignment with Betty's as simple as possible and to have the least amount of confusion. They did not support the specialized part as well, because as as part of nursing, you have nurses that are specialized, and that specialization doesn't mean independent. It means it's their study. They may be specialized as a peds nurse, or specialized as a labor and delivery nurse, or specialized as a wound care specialist, et cetera. And so having that added to the naming convention may really be confusing, especially with all of our nurse practitioners having to be licensed as an RN first. And so we're just with a lot of conversation around that. They chose to forego any naming convention until it became the 104 NP, which was independent, and to not have that a requirement on their list of letters after their name, that it would only be viewable on the board's website in the Breeze lookup.
This is Tricia. Yeah, I just want to align myself with some of those comments about, just the confusion. I'm somebody, I'm new to this, and so I'm awkward second guessing a committee that's been working on it and making a recommendation. But I'm someone who's been going to nurse practitioner for a long time, and I'm just not sure really what a few more letters really adds to that practice. I am very concerned about, the public just being confused about, this alphabet soup. So, I really, my desire would be to keep it very simple.
So do we have anybody that wants to make a motion on this, or do we want to open it up to public comment first before a motion is made so you can get more input? What are the thoughts of the board members?
I'd like to, open it for public comment.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Dr. Stephanie Dittmer would like to make a comment. 1 second, please.
Queuing that up, I want to make a reminder that it is 11:54. We do have a scheduled lunch today from 12 to 1. So as soon as public comment is completed on this and a motion is made and voted on, we will be going to our lunch break that will last until 1 o'clock.
Okay. Go ahead, Dr. Dittmer.
Yes, thank you very much. This word specialized nurse practitioner clearly stands apart from the nurse practitioner label and clearly fits the AB 890 past legislation. To change the naming convention to independent is directly in opposition to the past legislation. AB 890 states that a nurse practitioner shall verbally inform new patients language that's understandable. Thus, as Mary Fagan just stated, the intent of the law of trying to get nurse practitioners into an underserved area so that they understand what it is that they are receiving in their medical care is the whole point of what we're discussing. As a physician who has supervised nurse practitioners, I disagree wholeheartedly with Mrs. Wood's comment regarding the movement in healthcare regulation being long overdue, and I'm insulted that other physicians and community members who continue to raise concerns about how a lack of transparency and accountability in this process discriminates against what is the majority of community members in this state. When she laughs about her experience about the public and doesn't ask about her personal experience, she actively disregards the concerns of the public and the physicians. When she states it is a legal thing more than anything else, she's exactly referring to the reason why the BRN and the Npac should be following legislation passed. You can only practice independently if you jump through these hoops, is what she says. Those hoops need to be delineated. Patient core, the safety is the core of what we're doing. Patients deserve to know the difference. The concern about the alphabet soup that is already placed behind the nurse practitioner's labels does not independently tell patients what they can or cannot do, or that they are qualified to do what they're doing. I think this is a serious topic. And again, I want to voice my concern that I feel that these issues are not being taken seriously as both a Latina physician in the state of California. Thank you.
Thank you. Margaret Parsons would like to make a comment. 1 second, please. Go ahead, Margaret.
Thank you very much for the opportunity to address this important issue. I also have the same concerns as Dr. Dittmar as a physician who sees patients and working with patients trying to understand the difference between PAs, NPs, and the training people have. I find that the word independent is actually very confusing to patients. They're not clear exactly what that means. The term specialized is a term that implies extra training of a level to raise to a higher standard. And I think that's reflective of the work that the 103s and the 104s are doing. I understand the confusion and perhaps the different types of specialties, psychiatric, pediatric, whatever the specialties are, but it still is a word that implies someone has done extra training, has gained extra expertise. With the language also regarding the Spanish terminology that is set in statute that allows for the same language to be there for the patients that are Spanish speaking or bilingual to not be confused by two different words. So the word specialized does the job of implying that extra level of training, the extra work someone has made, it shows a higher level, and it meets the needs of statute and a basic understanding without extra layers of confusion. I agree, patients don't understand what all the initials after anyone's name means. So keeping it simple and not adding words that don't clarify. Specialized is a word that is understood across all levels of lay language. Independent is a word that isn't going to make sense to those in a medical language if you're not in medicine. We know what independent might mean some of the time, in those of us in medicine, but to our patients who are not in medicine, independent is a very confusing, doesn't make any sense word. Specialized is a familiar word that implies extra training and fits the layers of what we're required in statute to do with our Spanish-speaking patients, which we all know is the majority of all of our second language people in California. It would be a disservice to not recognize that. So I thank you for your consideration of this problematic issue and to give it due consideration because patients need to understand as best they can, and we need to make it as easy as possible for them. Thank you.
Thank you. Board President Trujillo, there are no other public requests for comment. Would you like me to close this window?
This is Betty. If I've insulted somebody, it certainly was not meant to be. And I do take this extremely seriously. That's why I'm trying to formulate language that the patients will also understand. And the other thing is nothing prevents the organization from doing a booklet or paper as to, in any language that they want, as to what the different roles are and what they do.
Thank you, Betty. I think for now, let's break and we'll come back and discuss this further and probably take a vote. Is that okay, Reza? Or do we need to vote before we go?
It's up to you. You have the option.
Yeah. So why don't we come back and discuss this further and take a vote? We'll break for lunch. All right. Thank you, everyone. I'll see you at 1 o'clock.